Bon après-midi. Hello. I'd like to begin by acknowledging that we're all gathered here today on the traditional unceded territory of the Algonquin Anishinaabe Nation. Happy to be joined this afternoon by Marci Ien, the Minister of Women, Gender Equality and Youth. I also want to welcome two other people here today. Morrell Andrews, whose advocacy on behalf of sexual assault survivors has moved a government, and Benjamin Roebuck, who is the Federal Ombudsman for Victims of Crime. I thank you all for being here today as well. Earlier this afternoon, the Honorable Mark Gold, the government representative in the Senate, introduced Bill S-12. This legislation will strengthen the National Sex Offender Registry in response to the Supreme Court of Canada's decision in Ndlovu, and will make the criminal justice system more responsive to the diverse needs of victims and survivors. Sexual offenses are amongst the most heinous and degrading forms of violence. They have devastating impacts on survivors, who are disproportionately women and girls. Police must have the tools they need to investigate and bring sexual offenders to justice. Those tools also keep our communities safer by preventing further crimes. Le Registre national des délinquants sexuels est l'un de ces outils. Il aide la police à accéder à de l'information à jour et cruciale à propos des délinquants sexuels pour prévenir et enquêter sur les agressions sexuelles. Nous sommes ici conscients que notre système de justice doit en faire plus pour répondre aux besoins des survivants. Certaines victimes veulent rester anonymes. Certaines veulent partager leur histoire. D'autres veulent mettre cette épreuve derrière elles et que le système criminel ne le recontacte jamais une fois leur agresseur condamné. C'est leur droit. D'autres veulent être gardés informés de chaque développement. C'est aussi leur droit. Il n'y a pas de bonne ou de meilleure façon d'être une victime, une personne survivante. Nous ne pensons pas que le gouvernement devrait décider à leur place. Si nous voulons véritablement traiter les victimes et les personnes survivantes avec dignité et respect lors du processus judiciaire, nous devons leur donner le pouvoir de prendre des décisions qui leur conviennent. Which brings me to Bill S-12. What does this legislation do? First, it responds to the Supreme Court of Canada and Ndlovu decision that I mentioned earlier. And second, it addresses important recommendations made by the Justice Committee in its report, Improving Support for Victims of Crime, a report that builds on years of advocacy from victims groups. I will begin with the Supreme Court decision. Last October, the Supreme Court struck down two criminal code provisions related to the National Sex Offender Registry regime. It found that requiring all offenders to be automatically registered on the registry to be unconstitutional. The court also found that making it mandatory for certain offenders to be put on the registry for life is inconsistent with the Charter of Rights and Freedoms. The Supreme Court gave Parliament a firm one-year deadline to respond to the decision regarding automatic registration. This means that unless Parliament passes this bill by October 28, 2023, no new names can be added to the registry. In light of that, I trust that all my parliamentary colleagues share my commitment to making sure that this situation does not happen. Canadians expect us to work together and quickly to preserve the National Sex Offender Registry by passing Bill S-12. Globalement, le but des amendements est de protéger le public des agressions sexuelles. À cette fin, cette législation requiert l'enregistrement automatique des délinquants sexuels dans deux circonstances. Premièrement, tous ceux condamnés pour agression sexuelle grave envers un enfant, c'est-à-dire que l'accusé a été poursuivi par voie d'acte d'accusation et a été condamné à 2 ans ou plus de prison. Et deuxièmement, les agresseurs sexuels récidivistes, soit ceux qui ont une condamnation antérieure en matière d'agression sexuelle ou qui doivent déjà se plier au registre. Nous proposons aussi que tous les délinquants sexuels soient obligés de s'enregistrer au registre, sauf s'ils peuvent démontrer au juge que cela irait à l'encontre des objectifs du registre. Cela devrait avoir pour conséquence que presque tous les délinquants sexuels seront inscrits au registre, tout en permettant d'assurer que le registre soit conforme à la Charte. Les amendements que nous proposons aujourd'hui permettront aussi aux juges de continuer à ordonner que certains délinquants s'enregistrent à vie. Cela inclut les agresseurs trouvés coupables de plus d'une infraction à la fois, si cela indique qu'il existe un risque de récidive. I want to highlight one other important change. We have listened to the provinces and territories and law enforcement who have called for the registry to be modernized. Through S12, we are adding the non-consensual distribution of intimate images and sextortion to the list of offenses that require a registration. I had the privilege of meeting with several survivors of online sexual offenses and their families last fall. Their heartbreaking stories and their bravery have stayed with me. So I want to thank the Canadian Centre for Child Protection, 3CP, for facilitating that meeting and for the important and difficult work they do every day. Today's measures will further assist police to identify perpetrators and seek justice for victims. La seconde partie de S12 traite du fonctionnement des interdits de publication. Les interdits de publication sont utiles pour protéger l'identité des victimes, des personnes survivantes et des témoins, et les protègent d'abus et de violences supplémentaires. Toutefois, certaines victimes et personnes survivantes peuvent se sentir muselées par les interdits de publication. Et nous sommes d'accord que ces personnes ont le droit de raconter leur histoire si elles le souhaitent. Redonner de pouvoir aux personnes victimes ou survivantes de violences sexuelles constitue une approche tenant compte des traumatismes et de la violence et peut s'avérer cruciale dans le processus de guérison. S12 permettra de donner une voix plus importante aux victimes en exigeant que les procureurs fassent les meilleurs efforts possibles pour les consulter avant qu'un interdit de publication soit ordonné. S12 simplifiera aussi le processus de modification ou de révocation des interdits de publication à la demande des victimes. Le projet de loi augmentera aussi l'accès à l'information des victimes en exigeant des juges qu'ils leur demandent si elles souhaitent recevoir des informations sur le dossier après la sentence. Ces changements répondent directement aux demandes et aux inquiétudes exprimées à notre gouvernement par les victimes, les personnes survivantes et les parties prenantes, et ce qui concerne les difficultés d'obtenir des informations après la sentence. Les victimes qui en ressentent le besoin méritent qu'on leur redonne du pouvoir plutôt que les laisser dans l'incertitude. I also want to note the important work of the House of Commons Standing Committee on Justice and Human Rights. Its December report on improving supports for these victims helped immensely in framing our approach to these amendments. Taken together, these proposed amendments today will strengthen our justice system by helping ensure victims and survivors are protected, that their rights are respected, and that their voices are heard. S12 proposes targeted and strategic measures that will help keep our communities safer and strike the right balance between public safety and charter rights. S12 is important legislation for survivors and for public safety in Canada. I look forward to its passage in the Senate and debating and passing it in the House of Commons. I would now like to turn to Minister Ien to say a few words. Marci.
Hello, bonjour. I would like to begin by also acknowledging that we are gathered on the traditional unceded territory of the Algonquin Anishinaabe Nation. Thank you for being here today. David, thank you so much for laying out the specifics of what's being introduced in the legislation. Morrell, thank you for being here and willing to share your story and your lived experience. And of course, Ben, we're thrilled that you're here today, too. It means a lot. Merci d'être ici aujourd'hui et merci David et Morrell et Ben. It means a lot. As Minister for Women and Gender Equality and Youth, I want to really get into what this means for survivors and for their families. We know that survivors of sexual assault bear long-term mental and emotional consequences, and often the litigation process is re-traumatizing. The changes proposed today respond to the Supreme Court's decision, fills in the gaps in the National Sex Offender Registry, and gives victims more choices in how their cases are handled. These changes are ultimately about making sure that offenders are held accountable while centering the needs, and this is important, and voices of survivors. An important part of this legislation is improving the law on the publication ban. In the context of sexual assault, it means that in most cases, it is an offense to publish, broadcast, or send any information that could identify the victim or witness in the case, even if survivors give permission to do so. Now, this is usually the part where I would highlight the story of someone that this would impact. But because of this ban, we simply don't know the faces and stories of countless survivors. Take, for instance, a case in Ontario where a woman pled guilty because she broke her own publication ban. The crime that she committed? She simply shared the judge's reasons for convicting her ex-husband of sexually assaulting her. She shared this with her family and with her friends, and she was found guilty even though they all knew who her ex-husband was. Though through cases like these, brave survivors have come forward and they have fought the system, and one of them is here with us today, Morrell Andrews, and the women that you've been advocating with for so many years, Morrell. I'm so happy that you're here today because you personify what truth to power looks like. Thank you, Morrell. And again, thank you, Ben, for your work and being fearless in all that you do. I think it's clear to everyone, and you don't need a law degree to understand this, that yes, the ban is intended to safeguard victims and the people around them, but in reality, it can sometimes do the exact opposite. The legislation put forward today, once passed, will ensure that survivors have a say in whether or not they want their names published. It gives them the control to tell their own stories and to do so in their own words. Another part I want to highlight is the proposed change to require judges to ask victims if they want to continue receiving information about their case after sentencing. This is consistent with the Canadian Victims' Bill of Rights, which states that all victims in Canada have the right to information about their case. For some, when the court proceedings end, they choose not to receive any information. And for others, receiving timely information even after sentencing is key to their healing journey. This change will give survivors that choice and get them the information that they are rightly entitled to. Both of these changes have one thing in common. They ensure that survivors are supported, and not only supported, they are empowered. But the other side of this legislation is about making sure that our criminal justice system holds offenders to account for their crimes. In particular, when sexual assault is committed against those most vulnerable in our society. This means automatic registration to the National Sex Offender Registry for anyone that commits sexual offenses against children and repeat offenders. It also highlights the severity of heartless crimes such as sexual assault against people with disabilities, extortion, administering a noxious substance like date rape, and the sharing of non-consensual images or revenge porn. We all know that these crimes are horrible. I don't need to repeat that. But through this legislation, we are calling them out specifically and making sure that they are dealt with in a way that reflects their severity, their harm to others. And we're making it clear that there are serious criminal consequences. I'm hopeful that this bill passes into law quickly, because this is about protecting Canadians, making sure that the most vulnerable in our society are safe. This work is in addition to the more than $500 million in funding that will be going to women's shelters across Canada through the National Action Plan to End Gender-Based Violence, because we know that supporting survivors takes real systemic change. Through reforming our justice system, through investing in frontline organizations, creating transitional housing for women and children, and through listening, deep listening to advocates and experts, those with lived experiences. Nous pouvons réaliser tout cela et nous le ferons tout en respectant la Charte canadienne des droits et libertés afin de continuer à construire un pays plus sûr pour tous. We can and will achieve all of this while respecting the Canadian Charter of Rights and Freedoms, ensuring that we will continue building safer communities, a safer country for everyone. Merci beaucoup. Now, it gives me great pleasure to welcome to the microphone Morrell Andrews from My Voice, My Choice, to share her experiences.
Thank you, ministers. It's so thrilling to be here today. On the same day that my sexual assault case ended, and it resulted in a guilty plea, I found out that I was trapped by a publication ban that nobody told me about or seemed to even be able to properly explain. And this publication ban required a judge to supervise what I could say. I was terrified of somehow breaching it. Just weeks before, as referenced by Minister Ien, I had seen a story about a woman in Ontario who was charged and convicted for breaching her own publication ban for simply emailing a court transcript that included her name. I was afraid that if I said anything about my case, even with a guilty result, that something similar would happen to me. I quickly learned that these stories and the people behind them spanned across the country. From Nova Scotia to British Columbia, there have been so many people who have struggled when they found out that they had unwanted publication bans that had been put on their names without their knowledge or consent, and who have gone through considerable struggles in an attempt to remove these court orders that they didn't find to be very helpful at all. Today, we have a Justice Committee report, a very successful House of Commons petition, and over 500 emails that have been sent to parliamentarians. And we have a proposed fix today that recognizes what advocates, lawyers, and victims have been saying for many, many years. That victim complainants of sexual offenses fundamentally have the right to decide whether or not they want a publication ban, and that the criminal code simply needs to be amended and improved to acknowledge that not everyone finds anonymity to be a protection. From the perspective of a victim, an improvement to the way that the law functions around publication bans looks like an end to Crown attorneys that place publication bans on our names without even telling us or explaining to us what it means. It means an end to complainants who find themselves sleepless at night trying to interpret the law that was not really written for them and that finds that everyone wants to be anonymous. It also looks like an end to judges who give offenders and the accused an opportunity to weigh in as to whether or not a victim should be permitted to remove a publication ban that covers them alone. It looks like an end to victims being threatened with fines and jail time for simply attributing their own experience of harm. And it looks like an end to victim service workers who simply tell us to get our own lawyers and figure it out on our own. If these changes that have been proposed today were made years ago, we would not have the victims and complainants of today having to resort to Twitter DMs to ask for help or to create WhatsApp groups to crowdsource legal advice. But that's what's happening today. I am elated to see this federal legislation that addresses the gaps in how publication bans are actually being implemented in this country. The provinces and territories have a very important role to play, though, and I think that's something that can't be forgotten with the legislation today. Provinces and territories need to step up and acknowledge that there are inconsistencies in their Crown policies, and they need to do a better job at supporting victims and complainants who are simply trying to navigate the system. This is part of a very long journey to improve the legal system and make it more responsive to the needs of complainants of sexual offenses. But there's so much more that has to be done to address the epidemic of gender-based violence, to bring justice for missing and murdered Indigenous women and girls, and to ensure that everyone has access to justice and accountability in our system for the crimes that are committed against them, regardless of their race or their class or disability or gender identity or sexual orientation. Everyone deserves justice. Finally, I want to recognize all the people who have shared their experiences, both quietly and loudly, to make this change possible, especially my friends who are part of My Voice, My Choice. Thank you for entrusting me with your stories so that we could move this legislative mountain together. I hope that you see yourselves reflected in this bill in the many ways that would have made an excruciating process a bit more gentle and a bit more kind for you. Your struggles have cleared a path for those who will come after us. And I think that's just the most incredible thing, and one of the most special pieces that have come out of the legislation today. So thank you, everyone, especially those across the political spectrum who have helped us get here today. Obviously, the government and the Liberal Party, but also Conservative members and members of the New Democrats who have supported us in this work in many different ways. So thank you all for helping us get here. It's truly monumental. And my last message to parliamentarians is, please be decisive as you move forward with this legislation. It is marginal, but it is a huge improvement to a system and will have a meaningful impact on people who are just trying to make it through and find some sort of resolution to harms that have been caused. I want you to be ambitious, and I want you to work hard and demand something better for us. Thank you.
Thank you, Merrill. I know it's a long road to get to this platform today, so thank you for your courage, for using your voice with power. Hello. Thank you, Minister Lametti, Minister Ien. En tant qu'Ombudsman fédéral des victimes d'actes criminels, je suis responsable de formuler des recommandations visant à améliorer les droits des victimes et des survivants au Canada, ainsi que les services qui leur sont offerts. Today is a significant step towards stronger implementation of the Canadian Victims' Bill of Rights. Responding to the needs of victims of crime is not a partisan issue, but a foundational responsibility of government. I was so pleased, so happy to see the House of Commons Standing Committee on Justice and Human Rights adopt a unified recommendation to provide victims of crime with information about their rights automatically, rather than waiting for them to ask. Information is a gateway right. While the Sex Offender Registry is not a publicly available tool for victims, this bill will improve access to victim services and produce tangible benefits. At the time of sentencing, a judge will ask and record if the best efforts were taken to see if victims want to receive information after sentencing. And this option will also be added to victim impact statements. With consent, the law would allow victim contact information to be shared with the Correctional Service of Canada to help ensure victims are notified about key dates like parole hearings or the release of the person who harmed them. These measures respect federal, provincial, and territorial jurisdictions and privacy laws, and will ensure more equitable access to victim services for Indigenous and Black survivors who are currently underrepresented. This has been the top priority for our office since I was appointed in October, building on the work of each previous ombudsperson. Most importantly, today, we're listening to the voices of victims and survivors of crime and choosing to respond with compassion. Victims and survivors are worthy of respect, worthy of dignity, and worthy to receive information. Thank you.
We'll open it up to questions. On va ouvrir le micro aux questions.
Why does this legislation still require a judge's discretion? Why doesn't it give survivors a veto over whether to lift the publication ban?
We're trying to ensure, first of all, publication bans are there, Olivia, for survivors and for witnesses, and to protect them. So what we're doing is empowering them. There is often, in the view of, from the perspective of a survivor, an important reason to have a publication ban. But that might change over time, and so what this legislation does is give a clear process that allows the survivor to go back to the judge and say, I'm now ready for this to be public. And I want to be clear, I can't really see a situation where a judge denies that unless there's another person, if there are two victims or there's another person involved that may not want to. But in the vast majority of cases, I simply can't see a situation where a judge would ever say no to that demand, that application to have the ban lifted. It's really just a way to make sure that there's a clear process with steps so that it accounts for a decision to have a publication ban or a view on the part of a survivor to want one or to not want one at the outset or to change during the course of a trial or afterwards. And so it's just a way of making sure that we've covered all the circumstances in a clear and coherent way.
So is there a mechanism to appeal a judge's decision if he or she denies lifting this publication ban?
I am going to say there's the usual appeal process. I know there definitely is for the Endlavu part of the act, but I'll come back to you with a more specific answer.
I'd like to ask about protections after a case closes. What if the alleged perpetrator is found not guilty, but the individual, the complainant, has already named and given the interviews and have lifted the publication ban? What mechanisms are in place to protect the complainant from any filing of defamation or libel suits? After
Well, there isn't where the criminal charge has gone through a case. It's hard to envisage in a good faith laying of charges where there would be defamation. That being said, the normal laws of defamation are generally there as a baseline to protect individuals. But again, this goes through a process. It goes through a police investigation. It goes through a Crown, and the Crown will decide whether or not to lay charges. There's a pretty good guarantee there that there's no defamation charge possible when that process has been gone through and a trial has happened, even with a not guilty verdict.
Do you expect more complainants to come forward with these changes? Is that the hope? And the follow-up question is, do you expect it to improve conviction rates too?
What we want to do is make an excruciatingly difficult process at least a bit more easy with respect to the management of publication of information. That in and of itself hopefully removes one impediment. That power removes one impediment that might prevent a victim from coming forward initially to tell, let's say, her story and to go to the police and proceed with a trial. That's all difficult. This at least takes care of one impediment, and we hope that just has a positive impact on victims generally. That's our priority. If it helps certain victims to come forward, that's even better. With respect to conviction rates, I think it's neutral in the sense that we're here to protect victims, whatever the circumstances.
How confident are you that the changes to the sex offender registry provisions will be passed or will be upheld by the Supreme Court? It seems like in their ruling, and of course you would know better than I would, that they were pretty clear that the restrictions on judicial discretion when it comes to making an order that someone has to register were pretty I guess problematic, and that there's still measures in this bill that would make it mandatory for a judge to order someone to register.
So what the bill does, again, just in recap, is set, for virtually all cases, set a rebuttable presumption for registration. And so registration will happen unless a person goes before a judge and says, here's a set of reasons why I should not be on the register. So again, the default provision is registration. There's a rebuttable presumption. We think that in and of itself, again, this is the vast majority of cases, will pass charter muster. It's in fact what the parliamentary committee, and I've forgotten the date now, under the Conservative government at the time, but the parliamentary committee recommended. There used to be an old process in which crowns and judges would decide. That was found to be inadequate, and so the committee at the time recommended judicial discretion. The Conservative government went further and went with automatic registration, with the result that we saw in Ndlovu. So again, for the vast majority of cases, we have, I think, a pretty strong view that this will pass charter muster, and a lot of it is based on the work that initial parliamentary committee had done. The two cases for automatic registration are narrow. Child sex offenses, serious child sex offenses, and secondly, repeat offenders. And in both cases, I think not only is it narrow, but there's a good set of reasons to say this narrow exception is justifiable under the Charter. It's reasonable and proportionate, and ought to be upheld. So we're confident that this legislation passes muster under the Charter.
Minister, do you have any expectation of tracking how many people will seek to have the publication ban lifted? Is there any office that's going to be responsible for that?
Courts will take care of those statistics, but that's something that certainly we could look into.
And Ms. Andrews mentioned some cross-party support. I'm wondering if you did any consultations with any of the other parties and what your expectation is for the passage of this.
There have been a number of informal contacts and discussions. The Conservatives have said from the beginning that they wanted us to respond to the N'Lavu decision. They've said that quite publicly, so I will hold them to their word and expect that we'll get that kind of support. But also, as Morrell has pointed out, there has been cross-party support, and I've spoken to members from other parties about this, in principle, without giving up any parliamentary privilege. But certainly, I'm expecting a degree of widespread support across the House of Commons and the Senate as well.
I'm wondering if there's any money attached to this. If victims are going to be more supported through this law, will there be more money to support those victims attached to it?
Well, we're already doing that, as Minister Ien pointed out. We're already supporting through the Victims Fund, which is part of the Justice Department, as well as funds in Minister Ien's department. We're trying to, I think, help victims, not just in sexual assault cases, but other kinds of cases as well. And we're doing that investment. And I think, you've got the ombudsperson here for victims' rights. If you want to frame that to Mr. Roebuck or to anyone else here, happy to have them add to the answer.
I would love to hear from you.
Okay.
Thank you. Yeah, from my perspective, the investment in responses to victims of crime is being widened and diversified and embedded across government, which I think is a good thing. Makes it difficult to necessarily see how all the pieces are working together. So that's something that I hope to learn more and be able to have eyes on over the coming years. But the government certainly has put a large investment into responding to gender-based violence, and I think that envelope of funding is responsive as well to the needs of survivors who are responding to the publication bans.
Would you see the benefit in having the Justice Department track how often this is being used and how many times victims are seeking to have a publication ban lifted?
Yeah, I think that's probably a good question for Statistics Canada with the court surveys. So all of the things that pass through the court system are tracked, and so those numbers should be publicly available if they're consolidated. But the number of times that the applications are brought forward should be clear.
So to clarify, if someone applies to have their publication ban reversed or revoked, they can apply to the government for funding if they need to obtain a lawyer in this, or do we know that at this point?
Well, I'll let the minister speak to the consultation process in the bill and the consultation with victims about the initial application of a publication ban.
There isn't anything contemplated in the bill that is that specific. One would hope that a victim would have legal representation. There are legal aid regimes that the federal government helps support that are administered by the provinces in each case that would help. And there are a number of victim support services. I think of the CAVAC regime in Quebec, for example. All of those are helpful, but certainly access to legal counsel is critically important in these cases, and that's something that we try to do through a variety of different means.
If I might just jump in for a second, because so many points have been made. With regards to gender-based violence and the action plan that we have, these are negotiations that are happening and have been happening, but are happening right now. There is $500 million on the table. Consultations are happening between my team and my provincial and territorial counterparts. And I just wanted to comment on Morrell's point, because you mentioned the provinces and territories. That's the basis of the action plan. This isn't a partisan issue. This is going to be all hands on deck. And that is why our plan, and this is a cross-government, all hands on deck approach, is done in partnership with provinces and territories right across this country. They are the ones that know what they need. What's needed in Nunavut is not exactly what's needed in Ontario. They know who their grassroots organizations are, who the frontline organizations are on the ground doing the work. And that's why we're doing this in tandem with the provinces and territories, because as Morrell pointed out, we all have a responsibility in this work.
Ian, you mentioned that one example about a woman being charged by violating her own publication ban. I'd like to know whether or not you think this bill will result in a change of culture at the prosecution level, at the police level. Victims or survivors are often told that they should not speak out because they will ruin a case. And so in one way, it's almost blaming them, before a case even ends. I'd like to know your thoughts on that.
Many thoughts on that, because we're talking about systems, and you don't change systems overnight. But these are steps, and as Morrell pointed out, they might seem small, but they're quite big when you're a survivor or you're a victim. Am I hoping to see a culture change? Absolutely. Is this a step? Are these steps in the right direction? Absolutely. Is there a lot more work to do? Yes. But centering survivors and centering victims, which is what we're doing today, listening to what they need, is what this is all about. And I do know if we continue to do that and work together, we're going to get where we need to get.
Do you think there needs to be education, though, in terms of the prosecution, in terms of the police, whether or not they use that, say,
Absolutely.
Don't speak to media, don't tell your story case? Would you say that they need to be educated or trained that that is not a piece of advice that they give anymore?
You're speaking to the daughter of an educator. And so education is always a good thing. And yes, again, this is systems. It takes time for people to understand. It takes empathy and listening, great deep listening, to understand what those changes are. And it takes courage to speak out about what you need when you are a victim, when you are a survivor. So yes, I would say education is always the correct way to go. I would think that Morrell would agree with me, and other survivors like her, the women that she advocates with. I just think that, in fact, I know it's a good day when you have, people standing up here and saying, this is going to change lives, because I've lived this, and if I had this years ago, it would have changed things for me. And that really is what this is about today and moving forward. But you're right, education is a centerpiece of that.
So I'm told
Please add.
I have a couple reflections on the data piece, but also education for Crowns and also investments. So maybe first on data, it's one of the things that the group that I work with endeavored to find early on. No one measures the prevalence of publication bans in cases, and it's a real challenge to understand the issue if you don't measure it. You can't change what you don't measure. And it would be fantastic if provinces and the ministries of the Attorney General take the initiative to sit down and recognize, okay, we have this proposed legislation. We are aware of the issues and have been made aware of the issues for some time. This is not just a federal jurisdiction. This is a provincial and territorial responsibility as well. And so they need to step up and actually acknowledge that, the cultures within their ministries, create this hostile environment for victims who are simply trying to seek information about their own case and participate in the court process, which, both are rights enshrined in the Victims' Bill of Rights. We have Crown attorneys who will ask victims to send to them directly the case law in order to justify the removal of a publication ban in advance of the end of proceedings. We have Crown attorneys who have told us that they don't know if the Crown would consent to the removal of a publication ban if a victim has asked for it. And we have Crown attorneys that simply say, I don't know the process. So it is very evident across provinces and territories that there's a major piece of education that's missing. It's not appropriate for a Crown attorney to ask a victim to provide them with the case law. It's a bit absurd. And so the investment, I think, not only has to come in the form of, free legal advice for victims, but it's also making sure that those mechanisms are accessible. Because a lot of the time, you can try to speak to a lawyer who, is on that kind of pro bono list if you're a victim of a sexual assault, but they don't have time, or the lists aren't updated, or you don't know where to find them. I actually didn't even know that I had 4 free hours of legal advice through, being a victim in Ontario. So it's not only an investment into this education piece, but also, free resources for victims. If you look at the Department of Justice's website, there's a fact sheet on publication bans, but it's not very clear, and it doesn't explain the process and the mechanisms required to remove a ban through your own application. You don't really need your own lawyer. You don't need your Crown attorney to file the application for you. You could conceivably do it yourself, but no one knows how, and no one is there to help you. So it's, these really simple mechanisms and resources that can be put out there for victims who, want to find a way out of these bans and don't necessarily want to go through a lengthy process. I think this bill will improve that mechanism, which is great, because we just need clarity on what we need to do. And that hasn't been provided. So hopefully we'll see that, as one way to improve the experience of victims who do have publication bans and choose to forego them.
And I do have one last question online. So Jacques Galland, go ahead.
Hi, Minister Lametti. One question I wanted to ask you about is why does this bill codify a process where a hearing must now be held in order to determine if the publication ban should be lifted, where notice will be given to the accused? Because your officials on the technical briefing earlier said that any court hearing, such as this one, would involve still giving notice to the accused, where they'd be able to make submissions, for example, on whether the ban should be lifted or not.
Well, thank you for that question. First of all, as Jacques, as you've just heard from Morrell, we're codifying the process in order to make it clear that the decision the decision to try to revoke the ban or change the status of the ban lies with the victim, and the final decision goes to the judge. And it was, as you've just heard from Morrell's previous intervention, there wasn't always clarity there. So we have that clarity now. The language of the Act is drafted uniquely from the perspective of the victim, and so as I had just stated, I can't think of an example other than when there are multiple victims who have differing views on publication bans, that a judge would ever say no to the lifting of a publication ban when the victim has sought it at the outset or changed position during the process to have it lifted. That's certainly something we can look at in the legislative process to clarify, but it is clear that we are trying to empower victims here, and that let me step back. A publication ban is there to serve victims and witnesses. And in general, the principle in criminal proceedings is openness, and so it's an exception to that principle. And as an exception to that principle, it is the victim's views that ought to be taken into account. So we can certainly make that more clear.
What?
Yeah, thank you, Minister. Just because, like I was saying, your officials certainly made clear this afternoon that such hearings would still involve giving notice to the accused, which is something that I know a lot of survivors have said they don't want to have to go through, and that would still be involved under the process that's currently envisioned in the bill. But the other question I had for you is a section in the bill that now says a publication ban would cover information published in any document, broadcast, transmitted in any way, or otherwise made available. Now that sounds to me like a survivor sharing a transcript of a court proceeding, and I'm wondering, is that not the case?
Well, again, I won't at this point jump into the technical extent of that. That's for the ban, if the ban is in place. What we're doing today is allowing for survivors to not choose that regime in order to avoid that. And so that's part of the previous regime, if you will. We've now added another element to that, which is the ability of a survivor to choose at any point, really, in the proceeding or after the proceedings, to have that ban lifted.
Thank you very much.
Thank you, everyone. Merci beaucoup. Thank you.